By way of introduction, I just wanted to very quickly say that the research for this talk mostly comes from a book that I co-wrote with Rhiannon Markless on arbitration in 19th century England, which was published earlier this year. And it is the last in a series on the history of arbitration written by the late, great Derek Roebuck, which cover ancient Greece and Rome, and then England through at least the 8th to the 18th centuries. Unfortunately, I'm not going to be able to get through quite all of that in 15 minutes. So I thought instead I'd like to begin by illustrating how arbitration did change from the early modern period into the modern via a 5-minute walk down Fleet Street and the Strand on the edge of the City of London. And for that walk, I thought we could start in the pub, and specifically Ye Olde Cheshire Cheese, which was rebuilt shortly after the Great Fire of London and is still standing in a fairly similar state today. In 1700, it was very usual for an arbitration to take place in a pub or tavern like this one. And here we've just got the interior of the Cheshire Cheese where the arbitration might have taken place. The basic structure of the arbitration was for parties in dispute to agree to appoint one or more arbitrators, instead of using the costly and slow process of litigation. Let's say the people in dispute were perhaps two merchants. One had sent the other a shipment of wine on credit, but they disagreed about the quality and therefore the price. They would begin by drawing up an indenture that set out the terms and remit of the arbitration. Each merchant chose an arbitrator who might be a friend or colleague, and in our case, they would naturally appoint other merchants with experience in the wine trade. And here you could see a printed version of an indenture. The parties would then generally sign an arbitration bond. And here you can see an exemplar bond with spaces in which you could fill in the details. And the bond would oblige them to forfeit a sum of money if they did not comply with the award of the arbitrators. And that sum would typically be about double the amount in dispute, so that refusing to perform the award just wasn't a viable financial option. The two arbitrators then attempted to come to an agreement over all matters in dispute. They would hear any relevant evidence from witnesses and examine accounts, and would no doubt have the arduous task in this case of tasting the wine. They then made their decision, called an award, or if they couldn't agree, they would have nominated a third merchant as umpire, and his decision would be final. For our merchants, he might order a price for the wine and then say when the money should be paid, perhaps in instalments. There were two ways to force an arbitration award if either party refused to do what it demanded, which was usually paying a sum of money, but could be much more diverse. Firstly, you could sue on the basis of the arbitration bond. Secondly, from the mid-17th century, a new method emerged whereby arbitration was registered with the courts. And this was called entering your arbitration as a rule of court. This made non-performance a contempt of court that was punishable by attachment, meaning imprisonment. This process was legislated for by the Arbitration Act of 1698, which you can see here, which was authored by the philosopher John Locke. Court-backed arbitrations became more popular from the 1750s, and it's worth noting that significant legalisation of the arbitration process took place via its increasing interaction with the courts, but without further intervention from Parliament until about a third of the way through the 19th century. Now let's take that 5-minute walk to the west and simultaneously leap forward nearly 200 years to the building of the Royal Courts of Justice, that Victorian Gothic edifice still overlooking the Strand, which some of you may know. As part of the design for the building, the architect George Edmund Street included detailed features for an arbitration room where, when it opened in 1882, two parties might have their reference heard by an official referee, a barrister appointed by the Lord Chancellor. And I think the symbolism of that arbitration room is really significant because it gives an idea of the arbitration process finding a space in the very heart of the legal system. Following several pieces of legislation that brought arbitration more in line with legal norms, the parties would no longer use an arbitration bond, and the evidence from their arbitration might fill several books, where in 1700 it was quite usual to keep no records at all, or to simply have the arbitration award written up on a scrap of paper. Magistrates, who also acted as arbitrators, undertook a similar transition of venues, all the while dispensing informal justice via mediation or arbitration alongside their official duties. In the 19th century, magistrates increasingly sat in petty sessions in public buildings such as a pub, rather than fulfilling their duties from home. The establishment of the London police courts in 1839 marked an expansion of the stipendiary magistracy on increased wages. Official buildings followed. To use the most famous example, Bow Street Magistrates Court was established in a house, that of Magistrate Thomas de Vale, in 1741. A police station was established in 1829, and then a purpose-built court and station completed in 1881. A magistrate writing in the early 20th century gave a historical assessment of the role of police courts. To quote, "From the outset, the police court was patriarchal in its practice. The poor in their perplexities were invited to visit it as a sort of bureau of information and help, and they quickly adopted it as their own peculiar tribunal." The police court continued as a site of informal justice in place of the magistrate's house and the tavern. So the places used for private arbitration were really even more diverse than those public sites of arbitration would suggest, and the transition to public buildings was even more haphazard. The provision of arbitration rooms in the royal courts answered a specific need for spaces to carry out arbitration, the paucity of which was bemoaned by the legal writer Joseph Chitty in 1837. And he wrote, "Hitherto no place or places of meeting upon arbitrations has been set apart, which is much regretted, because the arbitrator is compelled very inconveniently to give up his own house or chambers, or is obliged to resort to a tavern, where the considerable charges for the use of a room too much increase the expense of each meeting. In every city or considerable town, one or more rooms should be appropriated, and the price to be paid for its use in matters of arbitration fixed at a very moderate rate." Of course, this kind of official arbitration room never came into being, and it wasn't just the charge for a room at a tavern that was the problem. One weaver and arbitrator of the early 19th century estimated that a shilling of drinks would need to be bought during only an hour's hearing. There was significant regional variation in the kinds of places that were available for arbitrations. Pubs and taverns, as we've already heard, continued to be used in areas where other public buildings were not available. Take, for instance, an arbitration in 1843 at the Falmouth Arms in Bisick, Laydock parish in Cornwall, where a miller of the same parish, an auctioneer from St Columb nearby, and a solicitor, Mark Simons of Brook Street, Lambeth, were called upon as arbitrators to dissolve a business partnership between the Bone family. Hotels were also used, including the Midland Hotel Derby in an arbitration in 1893 between the freemen of the Borough of Derby and the Midland Railway Company, and the Queen's Hotel Manchester in a dispute involving the London and North Western Railway Company in 1894. Various professional institutions in London were used as venues for arbitrations as well, including the Law Institution in 1851. The Institution of Surveyors had premises in London from 1868 that were used for arbitrations in 1876, 81 and 83, and these are only ones that I've come across in newspapers, so I'm sure there would have been many more. Some arbitrations used multiple venues, such as that of 1882-3, involving the Catlow brothers, who claimed their land would be devalued by a sewage scheme planned by the local board near them in West Yorkshire. The arbitration started in the Queen's Hotel Manchester, moved to the Institution of Surveyors, and then finished in the Law Institution. And just to show you the very grand Institution of Surveyors in London. The Times also ran advertisements for various private arbitration rooms in Tom's Coffee House, Cornhill in 1839, the Inns of Court Hotel, Holborn in 1875, and a suite of solicitors' offices in Chancery Lane that included use of arbitration rooms in the same building at a reduced price, obviously handy to the solicitors renting there. Many of the London venues were helpfully positioned near the Inns of Court, near the City of London, or both. All of the examples so far suggest that arbitration was in essence an indoor pursuit, which is not at all true. One significant advantage it had over court-based dispute settlement was the freedom to undertake extramural fact-finding. For instance, if landowners or businesses argued over access to a river or the quality of its waters due to their activities, an arbitrator, perhaps an engineer, scientist, or surveyor, could quite literally test the waters. Before he embarked on his political career, which saw him reach the office of Lord Chancellor, Lord Campbell undertook the kind of work that any barrister might have done at the time. And that, of course, included arbitrations. His biography gives a rather farcical description of arbitration in action from a letter to his father in 1817, which nevertheless highlights what a place-based process this was. From attending the Gloucester sessions, Campbell took the stagecoach to Glamorganshire, where he had a, quote, long pending arbitration, and it concerned the gable end of a house. He met attorneys from both sides at Neath, where a large crowd had also gathered, so that Campbell's taking a view of the premises apparently had the feel of a general election. Of the two parties, one Mrs. Tyler had the popular support, while Grant was noisily disapproved of. Campbell spent the next day hearing witnesses from 9 until 3, and then he revisited the wall in question when it was nearly torn down to inspect its construction. Campbell deemed it worth around £10, while the parties, according to Campbell, had each spent around £900 on expenses. Clearly not taken aback by such a sum, he went for a walk, dined, then spent the evening considering the evidence and drafting his award before taking the mail coach to Bristol at 10 p.m. Apart from being a nice day out for Lord Campbell, this story shows that place mattered in arbitrations in so many ways. The parties were left waiting with their dispute until Campbell was in the area for the assizes and found the trip convenient. They didn't want to travel to the court themselves, however, perhaps due to the distance, but also because a judge would not have viewed the wall in question. They may have regretted their decision after Campbell had the wall hacked apart. Campbell's description of the costs involved betray his scepticism about arbitration, although perhaps he would have questioned the fee he demanded. However, it's hard to assess the value of certain intangibles, like turning up and engaging the local community in the dispute resolution process, which may have been an unhelpful and unnecessary circus, but might also signal the restoration of the relationship between the parties and their wider circle. And indeed, that's very much the impression we get from a good many other records and stories. Arbitration may have developed increasingly strong ties to legal institutions and, especially in London, occupied spaces within and around legal infrastructure, but it continued to take place in diverse venues, and it is precisely this flexibility of the where, who, and how of arbitration that made it a consistently appealing alternative to the courts. Thank you.